scene that no one can ever be prepared for. No law enforcement training, no training of any kind prepares you for this. It's easy to forget that these are men and women with families, children, feelings, emotions. They're not some automaton performing a delegated function. They're people. They were required to give CPR to gunshot children, 3, 4, and 7-year-old children. They held these boys in their arms, knowing there was nothing they could do to save them. How long do those scars last? What day do you wake up from that and you're healed? How do you unsee such an abomination? Bond factors this court needs to consider today are set forth in Criminal Rule 46, nature and circumstance of the crime charged, and specifically whether the defendant used or had access to a weapon, including the seriousness of the offense. It's the most serious offense that we have on the books, Judge. This is it. You can't commit a more serious offense. So the nature of the crime charged is the worst crime that can be charged. Did he have access to a weapon? Yes, obviously he did. The weight of the evidence against the defendant at this point, Judge, we stand here with a full admission of the defendant. That also goes to the confirmation of the defendant's identity, and witnesses on scene did see at least part of what happened. Next, the court is to consider the likelihood this person would return to court if a bond were issued. Again, this is the most heinous crime with the most severe penalty under the law that we presented to the grand jury. That alone would be a major factor in discouraging a person from availing themselves to this court or any other. And the thought to flee and the likelihood of flight is great in the state's opinion. The danger he poses to the community is a factor that this court can consider, and I think with the facts in front of you, Judge, we can't name a person that poses a greater threat to the community. As his prior record goes, Judge, it is fairly minimal. He was charged with domestic violence in 2010. He is not, to my knowledge, on probation community control. Judge, the facts of this case are hopefully like no other we will ever see. When this case gets indicted in the Court of Common Pleas, I am certain that a no bond hearing will be held, and I would hope that would be granted. But at this point, at this juncture, we're going to ask this court to issue a bond we've never asked for before. I'm going to ask for a bond of $20 million. I hope I never need to request such a bond again.
Thank you. Date for preliminary hearing?
The date for the preliminary hearing, Judge, is 6/26.
No objection.
The preliminary hearing will be set for June 26th at 1 p.m. At this point in time, bond's going to be set in the amount of $20 million cash or surety. Anything else at this time, Mr. Gast?
No, Judge.
Mr. Young? Mr. Kalm, anything further?
Nothing at this time.
All right, thank you.
All rise. Court is in recess.